Have you ever found yourself in a contract dispute in Virginia? Whether you're a business owner, homeowner, or service provider, understanding breach of contract law is essential to protect your interests. A breach of contract occurs when one party fails to fulfill the terms of an agreement. However, proving this in Virginia, courts requires more than just showing someone didn't do what they promised. To establish a breach of contract claim in Virginia, you need to prove three key elements. First, there must be a legally enforceable agreement between the parties. Second, you must demonstrate that the other party failed to meet their obligations under that agreement. And third, you must show that this breach caused actual damages. Time is critical when considering legal action. In Virginia, the statute of limitations for written contracts is 5 years from the date of breach. For oral agreements, this window shrinks to just 3 years. Missing these deadlines can result in your case being dismissed regardless of its merits. Creating a solid contract from the beginning can prevent many disputes. A legally enforceable contract should include the legal names of all parties involved, clearly defined rights and obligations, any representations or warranties, specific terms and conditions, consideration or the value being exchanged, and remedies in case of breach. While written contracts provide the strongest protection, verbal agreements can be legally binding in Virginia under certain circumstances. However, some agreements must be in writing under the statute of frauds, including real estate transactions, agreements lasting more than 1 year, and promises to pay another person's debt. If you're facing a breach of contract claim, several defenses might be available. These include prior breach by the plaintiff, waiver of the breach, mutual mistake during contract formation, fraud, or one party taking advantage of the other. An experienced attorney can help determine which defenses apply to your situation. Sometimes a breach occurs before the performance date arrives. This is called anticipatory breach or repudiation, where one party clearly indicates they won't fulfill their obligations. In such cases, the non-breaching party can treat the contract as immediately breached and seek damages, wait to see if the other party eventually performs, or pursue alternative remedies. When a breach occurs, various types of damages may be available. Compensatory damages aim to reimburse the injured party for their losses. Consequential damages cover additional foreseeable losses resulting from the breach. Liquidated damages are predetermined amounts specified in the contract itself. In some cases, equitable relief, such as injunctions, may be appropriate when monetary damages aren't sufficient. Before heading to court, consider alternative dispute resolution methods. Mediation involves a neutral third party, helping both sides reach an agreement. Arbitration uses a private arbitrator to make a binding decision. Settlement negotiations between attorneys can often resolve disputes more quickly and cost-effectively than litigation. Understanding breach of contract law in Virginia is complex, with many factors affecting your rights and remedies. The specific circumstances of your case, the contract language, and the nature of the breach all influence potential outcomes. A qualified breach of contract attorney can assess your situation, explain your options, and help you navigate the legal process to protect your interests.